Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefield of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. I hope you have some fabulous plans. I have to tell you, I never do anything on New Year's Eve, and I don't know why. I just don't. So I'm probably going to have a snack and watch the ball fall and watch some movies. Lately, I've been watching, I know I'm very late to the party, but I've been watching Downton Abbey. Oh, it's so good. I love it. It's amazing. All right. So anyway, enough of that. We're here to talk about SB 261. And this is the last of these new laws that I wanted to talk to you about. I said we were going to have a December full of new laws, and sure enough, we are. So this new law is about wage judgments, okay? And I want to talk to you a little bit about that first, and then we'll get into what SB 261 does. So remember that if you have an employee who has a wage and hour claim, they can go to the Division of Labor Standards Enforcement. They can go to the Labor Commissioner, right? That's the DLSE, or they can go to court, okay? And they can get a judgment, a court-ordered judgment against you, all right? So if an employee goes to the Labor Commissioner, for example, there will be a judgment that is issued, and that judgment is enforceable in court, okay? So when we talk about these kinds of claims, over my 30 plus years of doing this work, I have had a lot of folks actually tell me, well, I think I'm just not going to pay it. I think I'll go out of business instead. I think I'll declare bankruptcy. Now, by the way, remember, you can't threaten to file bankruptcy as a way to get someone to take a settlement. That's completely unethical and illegal. But I understand when there's a big judgment out there, we all have to look at our options, and that may be an option on the table. What you need to understand in California, though, is when there is a judgment against an organization, that is something that can lead to personal liability outside of the company, okay? So it's very important that from a structural perspective, when you have a judgment against the organization for a wage and hour issue, you should not be ignoring it, all right? And SB 261, which is effective January 1, 2026, introduces a very high price if you do so, okay? So the real fundamental component of SB 261 is this 180-day requirement that they have for paying a judgment, okay? So this is not a flexible deadline, okay? This is a hard and fast deadline, and it really is quite a significant change in the enforcement structure here in California regarding wage claims, okay? So what SB 261 does is introduce significant penalties for unpaid wage judgments, up to 3 times the outstanding amount. So if you owed $10,000, you would now owe $30,000, and attorney's fees. And the whole point of this, of course, is to ensure that you comply with the judgment and to deter you, the organization, not you personally, of course, from non-payment, okay? Now, there are all kinds of things you can do here. You can set up a payment plan to try to spread things out a bit, but you're going to have to resolve the claim. And of course, you should be auditing your wage practices so you can protect yourself from future claims. Okay, so the legislature passed this law because they said that many California workers who win these claims never get their money. In fact, it looks like only about 12%, get this, 12% of judgments were fully collected between 2018 and 2023. And with those kinds of statistics, frankly, I don't blame some folks from saying, I'm just going to wait till somebody, comes after me. I'm just not going to affirmatively pay this judgment. Now, I can't sleep at night, if I were to do something like that, but hey, we all have our limits, right? 12%, folks, that is a very low number. Okay, now, The other thing the legislature said, well, obviously, if we have, 88% of folks not getting their money between 2018 and 2023, obviously the current penalty scheme is not effective to deter the non-payment. And many of these employers are just going to keep ignoring these final wage judgments. So the idea is to make these judgments more enforceable and to strongly incentivize employers to pay, all right? So, as I said, under SB 261, there's a several penalty of up to 3 times the outstanding judgment, including interest, if you don't pay within the 180 days. I also want to make clear, folks, that the 180 days is 180 days after the appeal period ends. You always have a right to file what's called a de novo, D-E-N-O-V-O, de novo appeal, where you can go to the Superior Court and you can have a judge hear your case if you don't think the DLSC got it right. By the way, you better be sure that they didn't get it right, because you're going to owe the other side's attorney's fees and costs, and you have to put up a bond before you can go to court and make that appeal in the same amount as the judgment. So you're not going to get out of paying the money, at least up front. You may get it back, but you're going to have to put up a bond. Okay, now, so as I said, 3 times the outstanding judgment if the judgment is not paid within 180 days after the appeal ends. It actually requires courts to award attorney's fees and costs to prevailing plaintiffs, not to employers, which is not a surprise. We never get attorney's fees and costs, or very rarely. But whether the employee brings the claim, the labor commissioner brings the claim, or a public prosecutor brings the claim. Now, the penalty is going to be split 50% to the affected employees, 50% to the Division of Labor Standards Enforcement for enforcement and education. That should sound very much like the Private Attorneys General Act here in California, where the penalties of those sorts of claims are also shared with the state. And the law extends what we call joint and several liability to successors of judgment debtor employers. So let me make clear what that means. Let's say your company's Acme company and you get $1 million wage an hour claim and you say, I'm not paying. I'm going to totally close Acme. I'm going to open up a new company called Beta. Okay. Well, if you've got any of the same people involved, which at least you will be involved, right? You are going to be, the new company, Beta, is going to be responsible for the judgments of Acme. That's just how it is. So business reorganizations, business sales, those are not going to erase liability. It just doesn't work that way. Now, interestingly, one of the earlier versions of SB 261 did require employers to be listed on a public poster, kind of a walk of shame, if they had unsatisfied wage theft judgments. Wage theft just means you're owed money as an employee, but those provisions were removed. So that's no longer in there. But I think it's kind of interesting. The legislature was really throwing the books at folks who are not paying these judgments. And obviously the enforcement tools in SB 261 are going to affect everyone, right? They're going to affect employees. They're going to give employees more leverage. That's going to be really important. They're going to get more money. Employers are going to really be punished if they let a judgment go unpaid for more than 6 months, and they can get assessed penalties far above the original judgment, including fees and interest. So that's a big issue. Also, if you're a successor company, so if you buy a company, you may want to include a review of outstanding wage judgments as part of your due diligence when you're buying that new company. The bill does make enforcement easier by requiring courts to award attorneys' fees and costs to prevailing plaintiffs, which of course will support the public enforcement efforts. And the courts are going to be negatively affected because their workload may increase, right? Because they're going to have to assess the full penalty unless the employer proves by clear and convincing evidence that they have good cause for reduction, which is a very high bar. It's just not going to happen. And I feel like as a small business owner that small businesses are really facing even higher stakes than others with this new law because, with cash flow issues that many of us in small businesses will experience now, and then it's a huge problem if you let these things go for more than the 180 days. Now, remember, if during those 180 days you negotiate some sort of an agreement, right, a payment plan, that sort of thing, then you're not going to be subject to the penalty of 3 times the amount. They call that trouble damages or trouble penalty. So just start negotiating right up front, right? Start trying to figure out right up front what's going on. Now, there are a couple of things that you should be doing. You should put these on your action item list. Obviously, please resolve these claims promptly. If you think you're entitled to an appeal, fine, post your bond, track your deadlines, and get the appeal done. If you really can't pay in full before the 180 days are up, talk to the employee, make sure you establish a payment schedule that you follow. You're going to need to track your deadlines, folks. It's just like leaves of absence. You got to have a way of tracking what's going on so you don't miss that 180-day requirement. You probably want to budget. If you do have wage judgments, you're going to want to consider them to be priority obligations and get those paid right away. As we tell you all the time, you should be auditing your wage and hour practices. We recommend you use counsel to help you do that, only because then the results become privileged. And of course, hopefully your employment counsel is going to know what the rules are, so it'll go more quickly. You're going to want to look at things like your employee classifications, timekeeping, overtime, meal and rest breaks, final pay, on-call pay, any of those sorts of things. And then you're going to want to make sure people are trained and they understand what the obligations are. You're also going to, I think it's important, just like with responses to the Equal Employment Opportunity Commission or the Civil Rights Department here in California, you're going to want to have a group or individual in your organization responsible for tracking the wage claims, the appeals, the payments. You want to make sure you're keeping proof of payment, that you're communicating with the Division of Labor Standards Enforcement or the opposing counsel. And then, as I said earlier, you're going to want to use some due diligence when you're considering a business deal to evaluate any wage judgments or liens for that company that you're intending on buying. You also might want to use indemnities or escrows to make sure that if something comes up later, that you're going to be covered for that. So obviously, you've got to carefully track, you've got to take action, you've got to be proactive. Those are sort of the watchwords that we always give you when we're talking about wage hour compliance and other employment law issues. I know some people can't stand wage and hour law, but for me, it's very nice because it's mostly definitive, right? You know when overtime is owed. You know when somebody should be classified as exempt or non-exempt. You do know, by the way. Some of you send me emails and try to give me the song and dance about why somebody is really exempt and doesn't need to be paid overtime or given rest breaks or meal periods. And, the first line in the job description is, carefully review magazines in the waiting room to ensure they are properly organized. That's made up, but you know what I'm saying, right? Water the plants. Like, people really have to be properly classified. So the good news is wage and hour law gives you a little bit of definite guidance, and you may choose to ignore it. And there's no judgment on my part, by the way. You're not here to please me. I just want you to know what is going on out there in the world. Whatever you decide to do with that information is 100% up to you. But I want you to be sure that you are aware of what is going on. That is what is critical. All right, everybody, don't celebrate too much tonight. I hope you're feeling okay tomorrow. Here's to a wonderful 2026, everyone. I wish you all good fortune and happiness and health and prosperity and everything else. I know the world is a little crazy, topsy-turvy right now, but do what you can in your own little universe. I think I told all of you, I went up to the Arctic Circle to see some polar bears back in October. It was the most amazing experience on so many levels. I got to go with my sister. I got to meet all these local people. I got to look at beautiful landscape. I got to see bears. But what I really learned about was conservation, just even more about, forget about climate change or global warming, whatever phrase you want to use. It's happening. I don't care what term you use. These poor bears, until about 2 weeks ago, didn't even have any ice on Hudson's Bay. That is not the way it's supposed to work. And we as human beings are supposed to be doing the right thing, right? So do the right thing in 2026, okay? Pick up your trash, be kind to each other, get sleep, eat your vegetables, just like your mom says. Everybody, thank you so much for being here, for supporting us, for a wonderful year. Happy New Year, and I'll see you in January. Before we sign off, I want to remind you about our 25th annual legal update. We have 3 sessions I want to make sure that you sign up for them before they fill up. We're going to talk about all the new statutes for 2026 and all the relevant court decisions, as well as any other agency developments. So go to our website, sign up, space is limited. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.